The Constitution of India provides every citizen the right to freedom of speech and expression. This right, however, along with others, are subject to reasonable restrictions from time to time. Defamation is one of those restrictions. Hello everyone, this is Snigdha Mohapatra and today I will be talking about defamation laws in India. Defamation is considered under the scope of Article 19 of the Indian Constitution and brings a serious questions in the minds of the people concerning its nature, since the freedom of speech is more of a positive right and should be properly utilized by the public at large. The reputation or image which an individual possesses in the society is out of his own endeavors. The truth be told, besides his life, a man if actually cares about something, then it is his reputation. Defamation is an offense of injuring a person's fame, reputation, or character with the help of false and malicious statements. In legal parlance, defamation is the making or publication of false statements, malicious statements intended to tarnish the image or reputation of the concerned person. It generally involves communication of such false statements to a third party. Defamation necessarily connotes false representation of statements without the consent of the defamed person. Only injury to feelings of a person does not constitute defamation. It must essentially lead to harm and loss of reputation. The defamed person may not be named, but an acknowledgement or ascertainment should be present. A person or a group of persons is said to be defamed when the publication is specifically implying towards the particular person or a group of people as a whole. There are mainly two categories of defamation: libel and slander. Libel refers to representation or publication in a permanent form, which includes in writing, printing, pictures, etc. In case of defamation through libel, the plaintiff needs to prove mainly two things. Firstly, that the defendant has published defamatory statements against him, and secondly, the statement has been viewed by other people. Slander is mainly of two kinds, namely slander and slander per se. In slander, the aggrieved party needs to prove that the defamatory statements were made against him and has actually caused him special damages, which means real harm caused which has affected him financially or in any other ways impacting his profession or business. There are three main essentials to prove defamation. First, the statement should be false or malicious. Second, the statement should concern the aggrieved party. And third, the statement should be communicated to a third party either by written or printed means or through words or gestures. In India, defamation is considered to be both a civil and criminal offense. Under the Indian Penal Code 1860, sections 499 to 502 deal with defamation with respect to injury to an individual's reputation. Section 124A of the code deals with defamation against the state or sedition. Section 295A deals with defamation hurting the sentiments of a religious community, whereas Section 153 deals with defamation of a particular community. According to Section 499 of IPC, defamation is defined as whoever, by words either spoken or intended to be read, or by signs visible or by visible representations, makes or publishes any imputation concerning any person, intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person, is said to defame that person. Defamation is a civil offense, is determined under tort law, and in such cases, the is on libel and not on slander. A fact to note regarding defamation under tort law is that defamation is considered harmful for the reputation of a living person, since defamatory statements need to be proved by the plaintiff. But in case of a deceased person, an action can be taken if needed if it is found that the reputation of a deceased person is at stake. Then the heirs of the deceased have full rights to file a suit and claim compensation. In general cases, if defamation is proved, the plaintiff is liable to be paid the required compensation. The celebrated case of Subramaniam Swamy versus Union of India upheld the constitutionality of the defamation laws in India. The court also held that one can be expected to get criticism, dissent, and discordance of their deeds, but it will not be morally or legally correct to tolerate defamatory statements. Herein, Subramaniam Swamy had filed a writ petition to decriminalize the following two defamation laws. The contentions that caused an uproar around the country were that to declare Section 499 and 500 of the Indian Penal Code 1860 unconstitutional and to declare Section 199(2) of the Code of Criminal Procedure 1973 unconstitutional. He further contended that these provisions were unreasonable restrictions on the constitutional mandate of freedom of speech and that it violates the fundamental rights bestowed under the under Article 19. The apex court, however, held that a person's reputation is an integral part of the right to life under Article 21, which is the heart and soul of the Constitution, and it cannot be disregarded at one misusing the right to freedom of speech. Thank you very much for watching and see you in another video.